and I brought him in. Chupka. It's like CH, but it's CI. All right, I'm ready on Newsom. This is case number. Oh, wait 1 second. I'm not quite ready. Hold on, give me 1 second. All right. Okay. All right. This is case number 224448201. The people of the state of Michigan versus George Michael Newsom. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for an arraignment. Appearances, please.
Morning, Your Honor. Christina Ritter on behalf of the people, P number 83505.
Good morning to this honorable court. Carla Marable, P number 62755, on behalf of Mr. Newsom. Mr. Newsom, please state your full name for the record.
Unmute, Mr. Newsom.
George Michael Newsom Jr.
Thank you, sir. Today is the date set for an arraignment. Ms. Marable.
Your Honor, we waive the formal reading and stand mute.
Court will enter a not guilty plea on behalf of Mr. Newsom, and I will set the matter for a pretrial conference. Give me 1 second. I'm sorry. Court will set a pretrial conference for Thursday, September 21st, if that's a good day for you, Ms. Marable.
Yes, that's a good day.
All right. Court sets a pretrial conference for September 21st. It will be on the court's docket for 8/25. As to bond, Ms. Marable?
Your Honor, I'm asking for a personal bond. Mr. Newsom learned of these pending charges. As soon as he learned of these pending charges, he came to my office, retained me. He doesn't have any prior criminal record. He's a veteran of the Vietnam War. He has worked and lived in the city his whole life. So we asking for a personal bond, Your Honor.
Any response from the people?
Judge, the people have no objection to a personal bond. We are asking for a no contact order for the complaining witness, Ms. Kashana Moore.
The court is going to set bond in the amount of $2,000 personal bond, no contact with the complaining witness. Anything further?
No, Your Honor.
All right,
No,
we're all set. Have a great day. Stay safe. Good to see you, Ms. Marable.
Thank you. Bye-bye.
Bye-bye. You're all set, Mr. Newsom, until September 21st.
Okay. Yeah.
I'm ready on Chupka. This is case number. Where did it go on my docket? Oh, here we go. Case number 224427501. The people of the state of Michigan versus Robert Clifford Chupka. The defendant is charged with 1 count of assault aggravated. Today is the date set for a final pretrial conference. Appearances, please.
Your Honor, for the record, Christina Ritter on behalf of the people. And Your Honor, I just received notice that the complaining witness is inside the courtroom. Mr. Bauer, if you can come into camera view.
You want him to sit down? You can come up to the podium. Oh, to the podium.
Thank you, Mr. Bauer. Good morning. Can you state your name for the record, please?
Eric John Bauer.
How you? Okay, bless your heart. Mr. Flanagan,
Yes, Your Honor.
with respect to Ms. Howard, I need some more information as to why they're claiming that they're not representing Ms. Howard. I need more information.
Okay, I'll call him back.
All right, thank you. All right, Mr. Basant, your appearance, please.
And good morning, Your Honor. Attorney Kevin Basant, P71061, on behalf of Mr. Robert Chuka, who's also present by Zoom video.
And did you state your P number? I'm sorry.
I did, just 71061.
That's fine. Mr. Chuka, unmute and state your name.
You have to unmute, Mr. Chuka.
Unmute and state your name. Uh-oh, he might have froze up.
Robert Clifford Chupka.
Okay, he's a little frozen. Okay. This might not work, Mr. Basant. His signal isn't good. But today is the date set. Mr. Chupka, I need you to stop fidgeting with your camera.
Can you hear me?
Yeah, he can't. Okay. All right. Okay. I always wonder why people don't turn off their camera when they want.
Can you hear me?
We can, sir. I really need you to get somewhere and be stationary.
Okay, I had to move to a different area, that's all. Go ahead.
Well, thank you for your permission. Can you please state your name?
Robert Clifford Chupka.
Thank you. Today is the day set for final pretrial conference. Mr. Basant, how are you proceeding?
So, Judge, we did reach an agreement with the people. Mr. Chuka is prepared to enter a no contest plea for civil liability. He has been advised of his right to a trial in this matter. At this time, he wishes to waive that right and proceed with this particular plea. Is that correct, Mr. Chuka?
Yes, sir.
And he's pleading to what, Mr. Basant?
I believe the amended charge, and Ms. Ritter can correct me, but I believe it's attempted assault or attempted aggravated assault. Aggravated assault. Is that correct, Ms. Ritter?
Your Honor, that is correct. And a part of that plea agreement is a recommendation from the people for a term of probation, 12 weeks of anger management, restitution, if any is applicable, and no contact with Mr. Eric Bauer.
That's correct, Judge.
All right. Mr. Chupka, I don't know why your camera is fidgeting like that. Are you holding your device?
Yeah, I'm holding it out, yeah. Do you want me to look at it?
It's not stationary. It's not stationary. I need you to get stationary.
Okay, I'm stationary.
All right, your lawyer has indicated that you want to accept the people's offer and enter a plea of oh, Ms. Ritter, that was the people's offer for no contest.
I'm sorry, Judge. Yes, the people have no objection to a no contest plea.
Right. Your lawyer has indicated that you want to accept the people's offer and enter into a no contest plea today. Is that what you want to do?
Yes, ma'am.
Sir, I'm going to share my screen, and on my screen is an advice of rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes.
Okay, you're not going to be able to put your head down like that. So are you having difficulty hearing us?
No, I can hear you.
Okay, so I need you to not keep putting your head down. I need your face to be in the camera, okay?
Okay, no problem.
All right. So have you had an opportunity to review for yourself or go over with your lawyer your constitutional rights?
Yes.
And when you did that, did you understand your constitutional rights?
Yes.
Do you understand that this is a misdemeanor and therefore you have a right to a trial? But if I accept this plea from you today, you will be giving up your right to a trial.
Yes.
Has anyone threatened you in any way? I need the courtroom to kind of be quiet for a minute. I'm getting a lot of feedback. I don't know if I'm getting the feedback from the courtroom. Have anyone threatened you in any way or promised you anything that was not placed on this record
No.
to get you to enter into this plea today?
No.
Are you currently on probation or parole?
No.
Finally, drawing your attention to number 11 on the advice of rights form. Do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would have to either request permission of this court to set aside your plea or request permission of the circuit court to appeal the conviction.
I understand.
With that understanding, do you still want to give up your rights to a trial and enter into this plea?
Yes.
All right, who's going to place the factual basis for the plea on the record?
Your Honor, I can if that's okay with the court, or Mr. Bassan.
I have no objections to that, Judge.
All right. Ms. Ritter.
Thank you, Judge. On June 6, 2021, at 1617 East McNichol Street in the city of Detroit, the complaining witness, Eric John Bauer, has filed a sworn complaint in this court stating that on the date and the location stated above, the defendant, Robert Clifford Shuka, contrary to law, did make an assault without being armed with a weapon upon Eric Bauer and did inflict a serious or aggravated injury upon said person without intending to commit the crime of murder or to inflict great bodily harm less than a crime of murder, contrary to MCL 750.81A subsection 1.
Mr. Bassan, is there a stipulation as to that factual basis for the purposes of this plea?
Yes, Your Honor, the defense counsel so stipulates those facts, Your Honor.
Then the court will accept the stipulation and in doing so will also accept a no contest plea to one count of attempted aggravated assault. Having accepted the plea, the court is going to set the matter for sentencing. Unless, is there any objection to immediate sentencing since the complainant is present today, or did you?
I would ask for an immediate sentence if possible, Judge.
All right, yeah, any objection from the people?
Judge, we have no objection if Mr. Bauer is in the courtroom and ready to give a victim impact statement. The people are ready for sentencing.
All right, then let me get my sentencing forms, hold on. All right, with respect to sentencing, then, is there anything on behalf of the people?
Judge, with respect to sentencing, I'm just asking the court to adopt the recommendations from the people regarding the plea agreement in this matter, Your Honor. It looks like this incident took place at a workplace where Mr. Suka and Mr. Bauer were both employees. I would defer to Mr. Bauer in his impact statement if they still work together. However, I would ask that there's no contact between the two parties, Your Honor. And the other terms and conditions, I will leave that in discretion of the court. As far as restitution, Judge, I believe that there are some medical expenses that occurred because of this incident. Again, I'll defer to Mr. Bauer during his impact statement if he'd like to express that to the court. If they are, Judge, I'm asking the court to set that first review hearing as a restitution hearing as well, to give the people an opportunity to go over those medical bills to see what would apply as restitution, and also provide that copy to the court if necessary, and of course, Mr. Bryant.
Mr. Bowers, would you like to address the court?
No comment.
No comment, okay. Mr. Bryant, on behalf of Mr. Chuka.
Yes, Judge, on behalf of my client, Your Honor, from my understanding, this case is
I
an old.
apologize. I apologize. I'm sorry for interrupting. Mr. Bowers, we need to know if you still work with Mr. Chuka.
No, I do not.
Okay, thank you. Mr. Bryant.
And so, Judge, from my understanding, this is an older case. The parties have not worked together for over 2 years. There's been no contact since this particular incident. I know that my client is extremely remorseful for the situation. He does not have an assaulted past or an assaultive history. This is a situation where, unfortunately, if co-workers get into it, and unfortunately, this incident happened. My client has actually been in counseling and therapy for the past year. Since this particular incident, working on himself and some personal issues. I foresee him having no further contact with the law, no further contact with this particular complainant. And I just ask that the court adopt a sentencing recommendation and allow Mr. Chuka to kind of move on with his life and proceed with his life, Your Honor.
Mr. Chuka, would you like to make a statement on your own behalf?
No, I'm okay. Thank you.
All right. So the court is going to ready to impose sentence. I never got into it with none of my coworkers, Mr. Bryant. You said coworkers get into it. I never got into it with none of my coworkers. I mean, I've been working since I was in college. I worked at Burger King. I worked at Wendy's. I worked at one of those smorgasbord places, and then I worked with Upward Bound. Then I worked at a law firm, a law office, and then I went to law school. Then I was working at the law firms and different places. And then I've been working for a long time. I never got into it with none of my coworkers where nobody would be charged with assault or aggravated assault. Now we might have had a disagreement, and we may have had a disagreement in terms of like I don't know, some stuff, but I never got into it with my coworkers. So I don't know. And I don't know, I mean, I never heard of no people fighting at the court, but they could, I'm not in human resources, so they might be fighting. Nonetheless, I don't know the situation. Nobody really told me what happened. So I'm at sentencing. Mr. Bowers didn't make a statement. Mr. Chuka didn't make a statement. Nobody told me what happened. So I don't know what happened. I don't know if it was real bad or if it was not so bad. I know that the original charge is aggravated assault, so I'm assuming there was an injury, but quite frankly, I shouldn't be sentencing and be assuming anything. So just remember that in the future, when we're doing immediate sentencing, the court has no idea of what the facts of the case are. Nonetheless, there was a recommendation, and I apologize. Let's go back. Was there anything? What was the plea agreement?
A recommendation, the recommendation from the people, Judge?
Yes, please.
A term of probation, 12 weeks of anger management, restitution, if any, and no contact with Mr. Eric Bauer.
All right. So the court is going to impose a 12-month probationary period. And because this is an attempt, what's the maximum penalty?
So the original is one year, Your Honor. So
okay, so this is a 6-month misdemeanor.
Yes, Judge.
yes.
Which also means it's probably a 2.5-year probation, up to 2.5 years probation maybe. But nonetheless, court is going to set a probationary period at 12 months. That gives us a final review date of August the 1st of 2024. And then I'm going to set her, again, okay, I guess I'll set a restitution hearing, but Mr. Bowers didn't say anything about needing restitution. He didn't address the court. He didn't say he got injured. He didn't say he had any medical expenses or anything like that. I'm going to, at this particular time, set the restitution at 0. I will allow an opportunity to present any restitution information at the first review, which I will set for October the 5th. Let me make sure. Okay, for October the 5th will be the first review. And restitution hearing, I suppose, but nobody said anything about restitution. All right. And then court is going to impose the following fines, costs, and fees. Mandatory cost of $210, a $250 fine, I didn't do a pre-sentence investigation, so there's no pre-sentence assessment fee. And the court is going to impose $35 per month oversight fees for a total of $420 for the 12 months. Additionally, the court is going to impose the following conditions. You shall not use or possess any illegal substances. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not drive without a valid driver's license. You shall attend 12 weeks of anger management through eBay. You shall submit to, strike that. You shall pay any outstanding tickets you have with 36th District Court. You shall clear up any warrants that you have anywhere. I'm not going to order any random urinalysis at this time. I am ordering that you will submit to a one-time drug screen. And depending on the results of that drug screen, then the court will determine if there's going to be any future drug screens. Additionally, you will complete 2 days, which is equivalent to 16 hours of community service. Mr. Basant, I need you to contact the courtroom to confirm Mr. Chuka's address and phone number so that we can forward that information to probation.
I will do so, Judge.
All right. Oh, and then actually, let me, I understand from the chief judge that there's a, that the urinalysis will be conducted at 36th District Court. So for that one drug screen that I am ordering, at this time, I'm going to impose $10 to the cost, to his cost for the drug screen. So the court is going to The total fines, costs, and fees at this time are $890. The issue of restitution will close on October 5th. The issue of restitution will close. If I don't have any information about restitution, October 5th, then the restitution will be permanently set at 0. Anything further?
Just one question, so I'm just 100% clear with my client. I know we have a review date on October 5th, but the total amount of probation was it 12 months or?
12 months, yes.
Okay. And so, Judge, I'm just curious, does the court allow for early termination at the halfway point or not?
I do.
Okay, all right, thank you, Judge.
Yes, if he is eligible. But I didn't say that because I don't know allegedly how much if there's any
With
restitution.
restitution, understandable.
So if I order restitution, if he can't pay it by the halfway point, then he wouldn't get the early discharge. But I'm cutting it off on October 5th, so at least that would give him 3 months to pay if it's anything to be still eligible for the early. Well, he can get, he could be discharged at any point after 6 months.
Understandable, Judge.
Okay. All right, then we're all set. Everyone have a great day and stay safe.
All right, you too. Thank you, Judge.
You're welcome.
Thank you.
You're welcome. Mr. Flanagan, can you see if the Howard case started as a felony, please?
No, Your Honor, it did not. On the proceeding April 14th, Ms. Stevenson is listed as the attorney, so.
Oh, you
Oh,
all,
there you go.
you all must.
Turn your volume up.
Sir, why would you, this is ridiculously ignorant. Okay. Somebody must have transposed the P numbers.
Right, that's what I'm thinking, yeah.
All right,
I'll fix it.
thank you. All right, good morning, ladies and gentlemen. When prompted to do so, please unmute and state your full name for the court. When prompted to do so, unmute. I said when prompted to do so. This person on this Tino, you are so disruptive to my court proceedings today. You've been disruptive all morning. You've been disruptive all morning. You have been disruptive all morning. Ms. Howard, I'm going to send you to a breakout room to speak with the lawyers. Please accept to join breakout room number 6, Ms. Howard. The person identified as Teresa, please unmute and tell the court your name.
I'm Teresa Bragg.
Teresa Bragg. Ms. Ritter, is this your witness?
No, I'm on the same
Oh,
case.
no,
with Ms.
ma'am,
Howard.
ma'am, I'm not speaking to you, please. Hold on. Ms. Ritter, Ms. Ritter.
Judge, I don't have Ms. Braggs on my list.
All right. Mr. Coger, state your name for me, please.
Michael Coger.
Thank you. Now, the disruptive person on this TNU U616AT, please unmute and state your name.
Can you hear me, Your Honor?
and state your name. I've been hearing you all morning and I haven't wanted to. Please state your name.
Clarence Reeses.
Everyone, please start your videos. Oh, I forgot to get your name. Mr. You said Krayshawn. This is horrible. Sir, get your ear away from that camera.
I cannot, I'm sorry, Your Honor.
Sir.
I'm so sorry.
Let me tell you something.
I cannot.
You need to come in
can't hear.
person. Come. No, you can't hear because you're.
I'm not trying to upset you, Your Honor. I just can't hear anything. That's the only way I can hear you is up there. I mean, it's unmuted and everything, and that's the only way I can.
Whew, this is blessing me. Let me put him this message is only to him. This message is not to the rest of you all. Okay, I'm getting ready to put up a message and it's only to him. All right, Mr. Krashawn, state your name for me.
Krayshawn McGee.
Thank you. He's not even looking at my note. All right, Jesus Christ. Mr. Coger, I'm going to send you to a breakout room. Please accept to join breakout room. Number 7, Mr. McGee, join breakout room. Number 8, wait for the lawyer to come in to speak with you. Now, Miss Teresa, you're not on my docket. Unmute and tell me what brings you to court today.
I'm on the case with Miss Howard.
What do you mean by that? You're the witness?
She's a co-defendant.
What's
And
your
when I
last
tried to
name?
look up Bragg,
Mr. Flanagan, help me with that.
Ms. Bragg is set for a pretrial August 29th at 1:36 p.m.
You're not today, ma'am. Have a great day.
okay, thank you.
Bye. Sir, you have to come in person. You have to need, I don't even know what happened. Okay. Good morning, Ms. Langowski. I'm going to send you to a breakout. Whoops. I'm going to send you to the breakout room. Wait for the lawyers to come in to talk with you. Please join breakout room number 9. All right, let me tell them I'm ready. Whew. Ms. Ritter,
Yes, Judge.
what happened to your complaining witness?
I don't know. He left.
He
I know
did.
he left the waiting room and he never logged in because he was on an iPhone.
He did. You might want to get him back.
I'll try to call him, Judge.
Good morning, Mr. Cripps. Unmute. Looks like you're driving. I can't hear you, Mr. Cripps. Oh, wait, there we go. Now you can. Now you should be able to unmute.
Good morning, Judge.
Good morning. You're representing Adams.
Yes, I am, Judge.
Do you know where your client is?
I've been trying to locate him all morning.
Okay,
He's not responding to my phone calls.
all right. You can continue on where you're going. I will have Mr. Flanagan call you if he comes before I end my docket, but he's not here. If he doesn't come, I'm going to adjourn it because it's the first scheduling. So I won't KPS him today. I'll adjourn it and send him a notice, but we can call you if he comes.
Thank you, Judge. I appreciate that.
Okay, you're welcome. Have a great day if I don't see you again.
Who is the prosecutor handling the case today?
Miss Ritter, Christina Ritter.
Okay, so I know who to contact in the future to work this out.
Yeah, or look, hopefully she'll still be the prosecutor because they say the city's supposed to be that. Look, Kim Worthy is in some agreement with the city to take over.
Oh, that's fascinating.
Yeah, it is. So we'll see. But right now it's Miss Ritter.
Okay.
All right. We'll call you
Thank
if your client comes. You're welcome.
Thank you, Honor. Have a great day, everyone.
All right, you too.
Okay.
Miss Stevenson, she's not reading her text, so I'll be right back, but I'm ready. I'll text her again. Maybe this time it'll be a little bit more. Ms. Stevenson, are we ready on Brookins?
Ready on Brookins, Your Honor.
Mr. Brookins, step up to the podium, please. All right. This is case number. These are case numbers 224501501, 194464801, 234442201. The people of the state of Michigan versus Diambo Antonio Brookins. The defendant is charged with one count of assault or assault and battery as to each matter. The 2023 case is scheduled for final pretrial conference. The other two cases are scheduled for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson, appearing on behalf of Mr. Diambo Brookins. Mr. Brookins, sir, please tell the judge your full name.
Diambo Antonio Brookins.
Thank you. Today is a day set for pretrial conferences and final pretrial conferences. Ms. Stevenson, how are we proceeding?
Your Honor, with regard to case number 22045015, and with regard to case number, defendant number 1, and with regard to case number 1904464801, we would move for dismissal for the complainant's failure to appear in each of those matters. With regard to 2304-442201, Mr. Brookins will continue the plea of not guilty and ask that that matter be set for jury trial.
Ms. Ritter.
Your Honor, with respect to case number ending in 015 and case number ending in 648, it's at least the second scheduling of the pretrial conference, and the court did require the complaining witnesses, Ms. Sherry Davis and Mr. Khalid Al-Mohammed, to appear for today's pretrial conference, Your Honor, and I have not seen the complaining witness in the waiting room, nor have I spoken with the complaining witnesses to those cases. I don't have an explanation as to why they are not present, and at this time, we will not be able to proceed with respect to those two cases.
Can the individual on the Motorola please unmute and state your name?
Darius Copeland.
Thank you. Mr. Copeland, please accept to join the breakout room.
Okay.
Wait for a lawyer to come in to speak with you.
Okay. Thank you.
You're welcome. With respect to the case ending in 015 and case ending in 648, today is the date set for pretrial conference. The complaining witnesses were required to appear. They have failed to appear, and the people have no explanation for the failure. The court is going to grant defense counsel's motion and dismiss those cases without prejudice for failure of the complainant to appear. As to the final pretrial conference case, I'm sorry, Ms. Stevenson, you said, how did you want to proceed?
Thank you, Your Honor. We would ask that that matter be set for jury trial.
Court is going to continue the not guilty plea on behalf of Mr. Brookins. I will place Mr. Brookins on the jury trial track. I will give Mr. Brookins a final pretrial conference. For Friday, March 1st, 2024. At 9:19. And at that time, we should be able to give Mr. Brookins a jury trial date. Bond will continue with no contact with the complaining witness. With respect to that date, the people should confirm that their witness is available. Anything further?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Brookins. Thank you very much, Your Honor.
All right, then, Mr. Brookins, you're all set. Have a great day. Stay safe.
Judge, I have the orders forwarded to Mr. Clerk for the, if he wants to.
Oh, Mr. Brookins, you can have a seat in the hallway and they'll bring you out copies of those orders of dismissal for your records, okay?
Okay.
All right, you're welcome. Oops. Why they show up as two separate documents? You scanned them separate?
Who are you
Mr.
talking about?
Flanagan.
Oh, no, Your Honor, I just forwarded them.
That Miss Stevenson did then.
It's two cases. What do you mean?
That when I get my documents, they scan together. So you scanned it. Don't worry about it. Just don't worry
Thank
about
you,
it.
because I'm so confused. I don't understand.
That means I have to sign them each in a separate document.
Oh.
However you sent them, you didn't send them where it's one document, two orders in one document.
Oh, I got it. That is true. That's true.
See how long it's taking me to sign two documents? Because I got to come out and go back in and pull it up. Yeah.
I'm sorry, Judge.
That's okay. It's just what we do. All right, I've signed them, Mr. Flanagan.
Yep, I have them printing them off now, Your Honor.
Do we have time for a breakout, Judge, with regard to the Burton matter? The people, the court, and myself.
Not at the moment.
Okay.
Who is Burton?
Mr. Burton has a 910.
No, we're gonna do Dials. I'm ready on Dials. We can go in there after we do these people.
Okay.
Please start your camera, Mr. Dials. This is case number 234436201. The people of the state of Michigan versus Joseph Dwayne Dials. Defendant is charged with one count of operating while intoxicated. Second offense notice. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Joseph Dials. Good morning, Mr. Dials. Sir, please unmute and tell the judge your full name.
Joseph Dwayne Dials.
Today is the date set for a pretrial conference. How are we proceeding?
At this time, Your Honor, Mr. Dials will continue his plea of not guilty. We're going to ask that this matter be set for a final pretrial conference. I believe that the people have tendered discovery. I have to double check for the paper, Judge.
They probably did because this Mr. Dials didn't come the last time at 8:35. Ms. Ritter, did the computer submit? Did the computer submit some discovery?
You know what, Judge? It probably did to Mr. Gregory, but I will forward that to Ms. Stevenson.
Why would it go to Mr. Gregory?
He's the attorney of record.
Ms. Stevenson is the attorney of record on all MFD cases. Mr. Flanagan, okay?
Yes, Your Honor.
All right. Court is going to set a final pretrial conference for October 2nd. How many do I have October 2nd, Mr. Flanagan?
Seven, Your Honor.
How many?
7.
Does that include this one or no?
No, with this, it'll be 8.
Okay, thank you.
Uh-huh.
October the 2nd at 9:05. Bond will continue with no drinking, no driving without a valid license, and urinalysis twice per month. If he has not already been referred, please refer Mr. Flanagan. I'm sorry, please refer Mr. Dials to pretrial services for submission to urinalysis.
Yes, ma'am.
Anything further?
Your Honor, I just sent, resent the paper discovery and videos to Ms. Stevenson, but nothing further for the record.
All right, then we're all set. Mr. Dials until October 2nd on Zoom, 9 o'clock. Have a great day, sir. Stay safe.
Thank you, Your Honor.
You're welcome. I'm ready on McGee. This is case number 234443701. The people of the state of Michigan versus Krishan McGee. Defendant is charged with 1 count of malicious destruction of property. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson on behalf of Krishan McGee. Mr. McGee, sir, please unmute and tell the judge your full name.
Krishan McGee.
Today is the date set for pretrial conference. Ms. Stevenson, how are we proceeding?
Move for dismissal for the complainant's failure to appear.
Ms. Ritter.
Your Honor, it's at least the second scheduling of the pretrial conference, and the court did require the complaining witness, Ms. Tamalia Bush Brown, to be present for today's pretrial conference. Judge, I don't see Ms. Bush Brown in the waiting room. Actually, I'm looking at the notes in my system, and it looks like the letter we sent out to the last known address came back undelivered, and the contact number we have on file is no longer in service. So at this time, Judge, I don't have an explanation as to why Ms. Bush Brown is not present, but at this time, we will not be able to proceed based on her failure to appear for today's second pretrial conference.
Today is the day set for the pretrial conference. It is at least the second scheduling of the pretrial conference. And while Mr. McGee did not appear the first time, apparently the complainant witness did not appear either. The court is going to grant defense counsel's motion. The people are unable to proceed without the complaining witness's cooperation. Mr. McGee, we will mail you a copy of the order of dismissal for your records. Sir, have a great day and stay safe.
Thank you. You too.
Thank you. I'm ready on overall. This is case number. Please do not unmute until asked to do so by the court. This is case number 224458301. The people of the state of Michigan versus Shante Lamar overall. The defendant is charged with 1 count of malicious destruction of property. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Shante Overall. Mr. Overall, sir, please unmute and tell the judge your full name.
Shante Lamar overall.
Today is the date set for pretrial conference. Ms. Stevenson, how are we proceeding?
We will move for dismissal for the complainant's failure to appear, Your Honor.
Ms. Ritter,
Judge, it's at least the second scheduling of the pretrial conference, and the court did require the complaining witness, Ms. Clarissa Passmore, to be present, Your Honor. I don't see Ms. Passmore identified in the waiting room. So at this time, Judge, if the unidentified device in the waiting room is not Ms. Passmore, the people have no explanation as to why she is not present. And at this time, we will not be able to proceed based on her failure to appear for today's pretrial conference.
and the person identified as Micah's iPhone, please state your name.
Micah Sledge.
Thank you. And the person identified with the last name Jackson, please state your name.
Tony Moore Jackson.
Ms. Jackson, weren't you here earlier, Ms. Jackson?
Yes, I got booted out somehow after I talked to the lawyer.
Thank you. Ms. Stevenson, can you put a plus sign by Ms. Jackson?
Yes, Your Honor, I will. Could Ms. Jackson actually go back to a breakout room? I had one final question for her.
Thank you.
That I don't see in the notes.
Vortex unmute, please state your name.
Jessica Jackson.
Thank you. All right, the court is going to send each of you to a breakout room. Please accept to join the breakout room and wait for the lawyers to come in to speak with you. Do not leave the breakout room until you have spoken with a lawyer. With respect to Mr. Overall, today is the date set for pretrial conference. The complaining witnesses was required to appear. They have failed to appear, and the people have no explanation for the failure. Notwithstanding the fact that Mr. Overall also failed to appear at the last court appearance, the complaining witness also did not appear at that court appearance. Court is going to grant defense counsel's motion and dismiss the matter without prejudice, as the people are unable to proceed. Sir, we will mail you a copy of the order of dismissal for your records. Please have a great day. Stay safe.
Thank you, you too.
Thank you. All right, Ms. Stevenson, we can go to the breakout room.
Thank you, Judge.
We can go to number 15.
Okay.
Please unmute and tell me your name. Please unmute and tell me your name. Okay. Is Ms. Jackson set or does she need to be brought back in and sent back?
Ms. Jackson,
Jackson.
Tony Moore Jackson is, I'll change her name. She's ready to go on the record.
I'm ready on Colger. This is case number 204457201, the people of the state of Michigan versus Michael Trayvon Colger. The defendant is charged with 1 count of prostitution solicitation. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Michael Colger. Mr. Colger, sir, please unmute and tell the judge your full name.
Michael Trayvon Colger.
Today is the date set for pretrial conference. Ms. Stevenson, how are we proceeding?
Your Honor, I'm going to ask that Mr. Colger be set for a final pretrial conference.
The court is, I'm sorry, go ahead.
At which point we do hope to resolve this matter.
The court is going to continue a not guilty plea on behalf of Mr. Colburn. I will set the matter for final pretrial conference. Do you already have discovery?
That's what I'm looking for, Judge. I haven't checked this morning, Judge. I apologize. I know that if I don't have it, I can request it of the people. And we can set it for as early as the court wants to set it. I am looking for a resolution on this matter.
Court is going to set a final pretrial conference for October the 2nd, 2023 at 9:00 a.m. If discovery has not already been submitted, it should be submitted by September the 5th. Bond will continue. Anything further?
Nothing further from the people, Judge, and it looks like the discovery was sent to Ms. Stevenson on June 1st.
6/1.
Yes.
Okay.
All right. Then we are all set. Have a great day and stay safe until October 2nd. We'll see you October 2nd.
Thank you, Your Honor.
You're welcome. I'm ready on Jackson. This is case number, or Moore Jackson, excuse me, case number 234431501, the people of the state of Michigan versus Tony. The middle name may be Sandra Moore Jackson. The defendant is charged with 1 count of guns, reckless use. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson on behalf of Tony Moore Jackson. Ms. Moore Jackson, ma'am, please tell the judge your full name.
Tony Denise Moore Jackson.
Today is the date set for a final pretrial conference. How are we proceeding?
Your Honor, on behalf of Ms. Tony Moore Jackson, we would move for dismissal for the failure of any complaining or necessary witness to appear. In the alternate, we would ask this matter be set for jury trial.
The court is going to deny the motion. I didn't require any witness to appear. Court will continue a not guilty plea. Place the matter on the jury trial tract. Setting a final pretrial conference for March the 1st, 2024 at 9:19. At that time, the court should be able to set a jury trial. Additionally, the people should confirm their witness. Anything further?
Judge, I'm looking actually at the investigator's report. I don't know why this wasn't brought to the attention of the court at the pretrial, but it looks like the relationship between the necessary witness and Ms. Jackson is that they were or still are involved in a dating relationship.
All right, the court is going to continue a not guilty plea. Set the matter for final pretrial conference. Oops. Transferring the case to Judge Austin Garrett. Final pretrial conference will be set for August 15th. No, that's too soon. Give me another date. That's too soon. When I ask for a date, the mail got to get to the people. They're giving me too early dates. I know that the docket is light over there, but I need at least 3 weeks when they're giving me a date because the mail has to be able to get to the people.
Okay, I'm calling now, Your Honor.
Tell them I want a date, the first week of September.
Okay, they put me on hold.
Miss Moore Jackson, how did you log in today? Did you log in using my name or did you type in my Zoom ID?
I logged in using your name.
All right, so you're gonna go back on that website at the date that I'm going to give you. And instead of clicking my name, you will click the name of Austin Garrett. There are 2 Garretts. You want the male, Austin, not Ruth, Austin.
Okay, can I write this down, please?
Yes, you may.
Could you spell his last name for me?
Garrett, Garrett. And you want Austin, not Ruth.
Okay, Austin Garrett, and the date will be set for?
I didn't give it to you yet.
Oh, okay.
Thank you so much. September 6th, 8:30.
September 6th at 8:30 for final pretrial. I wanted final pretrial conference.
Yep, final pretrial.
All right. So September 6th at 8:30, you're gonna log on to Judge Austin Garrett's courtroom. Anything further?
No, thank you, Judge.
Nothing for the record. I'll just advise Ms. Moore Jackson that I'll give you a call later, like maybe around 4 o'clock today, because this is not what we talked about. So I want you to understand what happened. I'll call you around 4 o'clock today.
Okay.
Thank you. Nothing further. Thank you, Your Honor.
All right. Have a great day, Ms. Moore Jackson. Stay safe.
You as well.
All right, I'm ready on Burton. All right, can the person identified as Damon please
Yes, ma'am.
and tell me your name, sir?
Damon Woolley Crenshaw.
Mr. Crenshaw, what time did you think you were supposed to be at court today?
Ma'am, I had.
No, I apologize. Please answer my question.
Oh, I'm sorry, ma'am. I thought it was 9:30.
9 o'clock. And so why are you coming to my courtroom at 10:30?
Because, ma'am, I had woke up and I had called 36 District Court because my court date wasn't popping up, and they said it was at 9 o'clock, and she said the best thing she wanted me to do is since it didn't pop up, that's not no excuse because ain't no excuses because she said I'm an adult, I'm 18, so she said just at least join. So that way that y'all don't think I'm trying to.
She said that at 9 o'clock this morning?
No, she said that at 10
So
10:20.
you just called at 10.
Yeah, because when I woke up, I was Googling my name still and it didn't pop up. And my mama was like, you need to call them because sometimes it just don't pop up on the site. So I called and they said it was today. And that was like,
Well,
sometimes
I'm
Bryant.
apologizing to you. When you came to court last time, I told you your date and your time. What you looking for something to pop up for?
No, because, ma'am, I had Joe court date and the Livonia court date mixed up.
Well, that's your business. Stop having so many court dates. Next time, I'm not gonna let you in. You come in an hour and a half late.
I know, ma'am. I apologize. I'm so sorry.
Yeah, you're gonna have to get yourself together because it could cost you your freedom. Next time you're gonna have a warrant out for your arrest. Please accept to join breakout room number 3 and wait for the lawyer to come in to speak with you.
All right, I apologize.
Mr. Burton, you can go ahead and start your camera. This is case number 214523101, the people of the state of Michigan versus Richard Antonio Burton. The defendant is charged with 1 count of operating with a high BAC, 1 count of operating while intoxicated. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Richard Burton. Mr. Burton, sir, please tell the judge your full name.
Richard Antonio Burton.
Thank you. So today is the date set for a final pretrial conference. Ms. Stevenson, how are we proceeding?
Thank you, Your Honor. Mr. Burton and I have had the opportunity to discuss this matter, and this is the opportunity to review with me an advice of rights form. It's my understanding that at this time, Mr. Burton wishes to avail himself of an offer from the people. He wishes to waive his rights incident to trial and offer the court a plea of guilty to count 2, operating while intoxicated. It's our understanding that count 1 would be dismissed, Your Honor.
Okay. Ms. Stevenson, do you see that nobody has come out of this breakout room the last 3 cases that I've done?
Didn't notice that, Judge.
I did. I noticed it. I've done 3 cases and nobody has come out of that breakout room. Okay. Mr. Burton, Ms. Ritter, is that the people's offer?
That is correct, Judge. That's the people's offer at this time.
All right. Mr. Burton, would you like to accept the people's offer?
Yes, I would, Your Honor.
Sir, I'm going to share my screen. On my screen, you will see an advice of rights form. My question to you, sir, is have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes, I have, Your Honor.
When you did that, sir, did you understand your constitutional rights?
Yes, I did, Your Honor.
Sir, do you understand that this is a misdemeanor and therefore you have a right to a trial? However, if I accept this plea from you today, you will be giving up your right to a trial.
Yes, I understand that completely, Your Honor.
Has anyone threatened you in any way or promised you anything that was not placed on this record to get you to enter into this plea today?
No, Your Honor.
Are you currently on probation or parole?
No, I'm not.
Finally, drawing your attention to number 11 on the advice of rights form. Do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal, and if you were to change your mind about the plea, you would have to either request permission of this court to set aside your plea or request permission of the circuit court to appeal the conviction. Do you understand?
Yes, I do, Your Honor.
Sir, with that understanding, do you still want to give up your right to a trial and enter a plea today?
I do, Your Honor.
Raise your right hand for me, please. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. Ms. Stevenson.
Thank you, Your Honor. Mr. Burton, on February 20th of 2021, were you operating a motor vehicle in the area of the M10 or Lodge Freeway at 7 Mile Road in the city of Detroit?
Yes, I was, Ms. Stevenson.
Thank you. And prior to operating that motor
I want
vehicle
you to
on that,
answer to me, though. She's asking, but answer to me. Ms.
I'm
Stevenson,
sorry.
go ahead.
thank
That's
you, Your Honor. And then prior, Mr. Burton, to operating that motor vehicle in that location on that date, had you consumed alcohol?
I did.
And did the consumption of that alcohol make you intoxicated?
Yes, it did.
Thank you. And for purposes of the plea, we would stipulate that the blood alcohol content was 0.279. We would advise the court that Mr. Burton has been under the bond condition of Your Honor, once per month urinalysis for the last several months. I don't believe we've had any reports of violation, and with that, defense is satisfied.
Are the people satisfied?
Judge, the people are satisfied and so stipulated for purposes of the plea to the blood alcohol content.
Court will receive the stipulation, and with that, the court accepts a guilty plea to one count of operating while intoxicated and dismissing count one. Having accepted the plea, the court is going to set the matter for sentencing October the 2nd, 2023 at 9:00 a.m. With respect to the sentencing, Mr. Burton, you have a right to be sentenced in person, or you may consent to being sentenced on Zoom. Which do you prefer?
Zoom, Your Honor.
Court will set the matter at 9:00 on Zoom. Prior to sentencing, you must submit to a pre-sentence investigation and a substance abuse evaluation through the probation department. Probation is going to contact you by telephone. If they cannot reach you, they will mail you a letter and leave you a message directing you to contact them. Make sure you respond to their letter or their phone call so that I can have the proper pre-sentence investigation on the date of your sentencing. Anything further with respect to Mr. Burton?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Burton. Thank you very much, Your Honor. Thank you, Ms. Ritter, and thank you, Mr. Burton.
All right, Mr. Burton, you're all set. Have a great day and stay safe.
Okay, you too. Thank you.
You're welcome. I'm ready on Howard. This is case number 224557102. The people of the state of Michigan versus Tarlisa Howard. The defendant is charged with one count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Tarlisa Howard. Ms. Howard, ma'am, please tell the judge your full name.
Tarlisa LaShawn Ann Howard.
Thank you. Today is the date set for a pretrial conference. Ms. Stevenson, are you all already representing defendant one or no?
We are, and that's a pretrial on August 29th at 1:30.
All right, the court is going to continue a not guilty plea on behalf of Ms. Howard. And we will What time is the pretrial conference scheduled?
1:30, Your Honor.
1:30. And is that a first pretrial conference or?
I think it's the first one.
Court is going to adjourn Ms. Howard's pretrial conference to August the 29th at 1:31. That one is important. 1:31. We're going to contact Ms. Carter to have counsel appointed for Ms. Howard, as the defender's office will be representing defendant number 1. All right.
Your Honor, would the court consider our motion to dismiss
I mean, I
for Ms.
would.
Howard today?
Maybe.
So it looks like this is it looks like today is adjourned pretrial for Ms. Howard, Your Honor. I'm suspecting that Pervez might be a transposition of one of the MFD attorney's P number.
It is.
Okay, so I believe that there would have been a motion to dismiss at the first pretrial conference on behalf of Ms. Howard.
Because she wasn't here. Ms. Howard
Got
wasn't
you.
here. So
Okay.
there was no motion to dismiss.
Okay, all right, got it. Okay, well, I still make the motion and, that is what it is.
Ms. Ritter, did the complainant, to your knowledge, appear at the first pretrial?
Judge, I'm looking at my notes.
When was the first pretrial?
That's why I'm a little confused. So my notes say that the first pretrial was March 14th, 2023, and it was adjourned to April 14th at 8:30. And then Ms. Howard failed to appear on April 14th. And then there's an arraignment on the bench warrant held on May 24th. And that's when the court set this pretrial for today. But nonetheless, Judge, I don't have notes that the complainant witness appeared for any of the court proceedings that were scheduled. So with that being said, Your Honor, it looks like there was notice in my notes. There was notice sent out to the complainant witness. And
I'm going to still deny the motion.
Okay.
Well, I'll address it again on August 29th at 1:30.
Okay.
Okay, thank you, Your Honor.
Because there's a capious history, and I'm going to just put the two together. Complaining witness needs to appear, though, and then I'm going to consider the motion for both defendants.
Okay.
Understood, Judge.
So let's hold off on contacting Ruth Carter. Hold off on contacting Ruth Carter unless I set it for final pretrial conference. So let's put it for 1:30. 1:36. Let's put it for 1:36. All right.
Sounds good.
All right. So you're all set, Ms. Howard, until August 29th, PM docket, 1:30, okay?
Yes, Your Honor.
If the complaining witness does not appear at that time, then the court will most likely dismiss the matter, unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Your bond will continue with no contact with the complaining witness. Have a great day. Stay safe. Give me 1 second and I'm ready on Copeland. All right. I'm ready on Copeland. This is case number 225762201. The people of the state of Michigan versus Darius Copeland. The defendant is charged with false welfare. And today is the date set for review. Ms. Stevenson.
Janice Stevenson on behalf of Mr. Darius Copeland. Mr. Copeland, sir, please tell the judge your full name.
Darius Roscoe Copeland.
Thank you. Today is the date set for review, and according to probation, Mr. Copeland was placed on a 12-month probationary period last year for 1 year. He was at that time ordered to complete 3 days of community service, and he was fined, or he was imposed $245 in cost. This isn't on the probation. This isn't on the probation review. I'm reading from my order.
Okay.
From my thing. And then he was ordered to pay $100 minimum per month towards his restitution. I don't know why there's nothing on the update regarding his community service or his $245. So, Mr. Flanagan, can you give me, do you have anything regarding his $245? What is his current balance?
The current balance is $5,604.
All right, so his total was $6,684 in restitution plus $245. He hasn't made his $100 payments. And I don't have anything on here that tells me about his community service. So his initial fines, costs, and fees was $6,929. His balance is $5,604. That means he paid $1,325. Oh, so he might have been making monthly payments. So it looks like he was making monthly payments of $110.
Your Honor.
Yes.
There is a payment history listed in the ROA, and there's one from May, June, July, and August. Payments made.
You saying May, June, July, and August of this year?
Yes, ma'am.
So he wasn't making his monthly payments, but he said, let me try to catch up. How much was his payment
right now?
All right, I'm looking on it now up in 2022. He did make payments in 2022. August 5th, August 9th, I'm sorry, 2022, August 12th, October, November, all in 2022. And then in May of this year, up until August 1st.
All right. Can you call Ms. Green and see if anybody has any information about the community service? Did your client do community service, Ms. Stevenson?
I'm going to defer that question to Mr. Copeland. Mr. Copeland, finished the 5 days of community service, sir?
It was 3.
3.
Unmute. You muted yourself. Unmute.
When I went to the probation department, they read off to me, only thing I had to pay was my restitution fee. I never was told anything about community service. If that was
Mr.
the case,
Flanagan, do you have my order?
I would have followed up with it, but I was never told that. And when I went to report to probation.
Okay. Thanks, Mr. Copeland.
And I have made all my payments on time every month since I've been on probation as well.
That's what it looks like to me, Judge, that there at least $100 payments made.
Well, why Mr. Flanagan doesn't have anything in January, February, and March of this
Look
year?
at the dates again.
But that's beside, I mean, I don't care as long
Yeah.
as it's the minimum, but Mr. Flanagan, do you have the order?
Yes, Your Honor, I have the order and I'm on the phone with Ms. Green now.
But does the order say community service?
No, Your Honor, it just says must make monthly payments of $100 towards restitution, no new offenses, and it has the review date.
Well, and I signed it.
Yes, August 3rd last year.
That's not correct. That's not a correct order. That's not a correct order. So you don't have to call Ms. Green, but that's not a correct order. All right. I guess I gotta be more careful. That's definitely not a correct order. So this was probably an AAG case, and I definitely checked off 3 days of community service, but that's not my issue. So here's the decision that your client has to make.
Okay.
It appears that he's only made the minimum payments.
Okay.
It means that he cannot benefit from the delayed sentence. He won't benefit from the delayed sentence. He's only made the minimum payment. He still has a huge balance. I will close the case out without improvement because the order was for 12 months. He's only paid the minimum payments. And I guess the other payments could potentially go towards the fines, towards the cost. But he can't get the delayed sentence, and it's going to be closed without improvement.
So I need to make sure that my client understands that, Judge. And I could be overlooking it, but I don't see delayed unless it's on the actual order.
It's not,
I see.
That's what I'm saying. That's not the correct order, and I signed it, so that's my fault. I can't blame it on anybody but myself because I signed it. But they clearly, I'm looking at his pre-sentence investigation, and I'm looking at my order that I wrote out. It was a delayed sentence, which is why it's very important to put delayed sentences on delayed sentence forms. But again, I signed it, so I don't know if it was submitted to me late, if I didn't review my notes when I signed it. I clearly didn't review my notes when I signed it. It was supposed to be a delayed sentence. Additionally, he had a $265 balance with this court. He was supposed to pay that. No new offenses, $100 minimum, 3 days of community service, and a delayed sentence. That was supposed to be. And if he paid that, he was going to get that. But I clearly didn't sign a delayed sentence order, and he hasn't made the payments. He didn't pay the amount in full. The plea agreement was for delayed sentence and paid full restitution, and they gave him monthly installments of a minimum of $100.
Your Honor, may I?
You may.
On June 16, 2022, it does say that it was delayed under 771.1. However, I just have a regular order of probation.
Yeah. It was supposed to be delayed, but it's not gonna be delayed.
Yeah, I mean, the sentencing date doesn't show that might, but can I talk to just one second. Okay, Judge, may I have Mr. Copeland back in breakout? Very, very briefly.
Okay. Okay, Ms. Stevenson.
Thank you, Your Honor. Having had the opportunity to speak with Mr. Copeland, we're asking that this matter be closed today. Understanding that it would be closed without improvement.
Court is going to close the matter. Without improvement. Anything further?
Nothing on behalf of Mr. Copeland. Thank you, Your Honor.
All right, Mr. Copeland, we will mail you a copy of the order discharging you from probation for your records. Have a great day. Stay safe. I'm ready on Jackson. All this time, does Ms. Jackson have on a white t-shirt? I want want to put Ms. Jackson back. I mean, oh, this is Ms. Langowski. I said Jackson. That's Ms. Langowski. I'm gonna put Ms. Langowski back in the breakout room.
Okay.
And then she's gonna change her shirt.
I have to change my shirt?
I'm ready on Jackson.
Yes.
Ms. Jackson, start your video, please. This is case number 145833901, the people of the state of Michigan versus Jessica Ann Jackson. The defendant is charged with 1 count of operating while intoxicated. Ms. Jackson, what's the issue? You can't hear us?
Yeah, I can't hear you.
Okay, ma'am, that's not gonna work. I won't do court with Ms. Jackson's ear up to the camera. Ms. Jackson is gonna have to come in person, or she's gonna have to get some headphones.
I can zoom in through my tablet.
I don't know, ma'am, but you can't have your ear up to the camera. So, Ms. Stevenson, I'll put her back in. I don't know if she's gonna zoom in on something else, but I can't do a review with her ear up to the camera.
Understood, Your Honor.
I'll put her back in the breakout room. I don't have anything else ready.
Let's see if Mr. Sledge just left and came back.
Hello? Okay.
So I'm gonna assume that Micah's iPhone is Micah Sledge. Ms. Stevenson, is Micah's iPhone ready?
Mr. Gregory, did you get a chance to talk to Mr. Sledge?
Not to Mr. Sledge.
Okay.
Sir, I don't know why you left the breakout room, but please return to the breakout room and wait for a lawyer to come in to speak with you. Is Jessica Jackson? Why is Jessica Jackson? Didn't I just send Miss Jackson back to the breakout room? Oh, maybe she logged in on something else. Let's see.
She's ready, right, Mr. Gregory?
She is ready.
Well, she was ready, but she was putting that ear up to the device, so she wasn't ready. But let's see. All right.
Okay, so now I'll head to breakout.
Okay, well, I'm ready on Jessica Jackson.
Okay.
If she starts her video. All right, Mr. Gregory, can you put your appearance on the record for Ms. Jackson?
Your Honor, Austin Gregory, P85193, on behalf of Ms. Jackson, who's present by Zoom. Ms. Jackson, please unmute and state your full name for the record. You have to unmute first, Ms. Jackson.
Jessica Jackson.
All right. With respect to Ms. Jackson, she was placed on 12-month probation back in April. This is her first review. She has viewed consequences. She has provided proof of her education. She has been testing monthly. However, she better stop testing positive for marijuana. So let me say this. I don't care that you're in the process of getting a medical marijuana card. You better not test positive for marijuana again without a valid medical marijuana card. If you test positive again, you're going into treatment. Now, I don't know why they didn't violate you. I don't know why there was not a violation submitted. But you're testing positive. And then she didn't report in June. That's another positive. Therefore, there are 3 positive tests. I'm going to violate you if this continues. I'm going to revoke your probation and I'm going to put you in jail. So we're going to stop. She still has to pay her $890 and she still has to do the victims impact panel. I'm going to bring her back in 45 days. If she's still testing positive, then we're going to have a problem. Anything further, Mr. Gregory?
No, Your Honor.
Court is going to set the matter for September the 21st. If she has any more positive or missed tests, then we're going to have to do something different.
Understood, Your Honor. Thank you.
All right, September 21st at 1:30. Oh, Mr. Flanagan, how many do I have at 1:30 on that day?
Eight, Your Honor, at 1:30.
Are they all reviews?
Yes.
How many do I have in the morning?
Just 3 and 1 discharge.
No. How many cases? I'm sorry.
Oh, okay. $17.
Court is going to set this matter at 10 o'clock.
Nothing further, Your Honor.
All right. We're all set until September 21st at 10 o'clock. No further positive test period at all. None. No missed tests. We're all set. Have a great day. Stay safe. I'm ready on Langowski. Give me 1 second. This is case number 194448301, the people of the state of Michigan versus Brittany Langowski. Middle name is cut off on the docket. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for review. Appearance, please.
Austin Gregory, P85193, on behalf of Ms. Langowski, who's present by Zoom. Ms. Langowski, please unmute and state your full name for the record.
Brittany Loretta Langowski.
Thank you. Today is the date set for review. And according to probation, Ms. Langowski has I need her order because this isn't, hold on. Oh, here it is. She has paid her fines, costs, and fees. She has completed her anger management. It doesn't say anything about her mental health treatment. Can you call Miss Bumpus and ask her if she has any verification of the mental health treatment? Mr. Gregory, what's going on with the mental health treatment?
Your Honor, the report that I got indicated that she was completed with her, she had no remaining conditions.
That's what it said, but the completed conditions doesn't say anything about mental health treatment. Completed condition says she's paid her balance, she's done her anger management, and doesn't say anything about mental health treatment. Her order indicated that she was supposed to continue with her mental health treatment. So has she continued with mental health treatment?
Your Honor, we may have to go back into a breakout.
Am I allowed to speak?
You may.
I am in therapy. I still do therapy. That was one of the things why I was in therapy when I got sent the thing that I was supposed to do. But yes, I am still in therapy.
And did you provide proof of the therapy to your probation officer?
No, I didn't know I was supposed to. I spoke with her a few days ago and she said everything was in, so.
Okay, well, let's see. I don't know why she would say that without giving me an update on the therapy. All right, so we'll wait and see what we get from Miss Bumpus.
Yes, I'm on the line with her now, Your Honor.
All right. Then in the meantime, I'm ready on Sledge. This is case number 145560002, the people of the state of Michigan versus Micah Denard Sledge. The defendant is charged with 1 count of retail fraud. Today is the date set for review. Appearances, please.
Austin Gregory, P85193, on behalf of Mr. Sledge, who's present by Zoom. Mr. Sledge, please unmute and state your full name for the record.
Micah Denard Sledge.
Thank you, sir. Today is the date set for review. With respect to Mr. Sledge, he was placed on a delayed sentence February of this year, and he was supposed to complete he was ordered to complete a drug test where he tested positive for marijuana without a medical marijuana card. He attended theft awareness and he paid his court balance. He has 8 hours of community service, and he's going to submit to another drug test. Mr. Gregory.
Your Honor, I apologize. Your Honor, Mr. Sledge is just asking for 30 days to complete his community service requirement, so he may be his 8 hours of community service, so he may be in compliance with the court orders.
But he's not in.
And he will
go-
test.
So, but is he smoking weed?
Currently, no.
Yeah. Is he smoking weed? So
We
if
have
I
talked to him
order-
about the need
If I
to
order
comply with court orders.
If I order Mr. Sledge to come down to the court and test today, is he going to test positive for marijuana? Might as well be honest, Mr. Sledge or whatever. Are you going to test positive for marijuana?
Your Honor, you're asking me?
Yeah, anybody. I want to answer for somebody.
Yeah, I would definitely test positive.
So why are you smoking weed without a valid medical marijuana card if I ordered you to not smoke without a valid medical marijuana card?
I mean, I just didn't know I needed a medical marijuana card with it being rec in Michigan.
I apologize. So are you saying you didn't hear me say it? Or you felt like, notwithstanding the fact that I said it, you decided you didn't need it because it's legal in Michigan?
No, I honestly didn't hear you say it. I did go to do the drug test and all of that, but I definitely didn't understand that you said I couldn't smoke without a medical marijuana card.
Mr. Flanagan, what did I order? Did I order that?
Look for his file, Your Honor, Sledge. Yeah, shall not use or possess any marijuana without a valid medical marijuana card.
Yeah, I knew. I thought I said it. I knew I said it. I knew I said it. So let's be clear about something. It's legal in the state of Michigan to leave your house whenever you feel like it. But if I say you gotta be home by 10 o'clock as a condition of your probation, then you gotta be home at 10 o'clock. It's legal in the state of Michigan to drink alcohol to your heart's content. But if I say no drinking while you're on probation, then it's no drinking. So you've clearly decided, or you said you didn't hear me. But one thing I pride myself on is being clear and articulate when I give my probation orders. That's one thing I know. I know that I said that. I know that I was clear about it. I know that my words came out in a way that you could hear me and understand me. So what I'm saying to you is this. You're going to stop smoking weed. And then you're going to come in for a drug test on the day of your next review. And if that drug test is positive, then we're going to assume that you have a problem, that you're addicted to the marijuana that you also freely say is not addicting. We're going to assume that if you cannot stop smoking weed today, that you have a problem with a substance that people tell me is not addicting, when we all know that it is. Just like alcohol is addicting. Just like somebody could be addicted to alcohol, just like somebody could be addicted to Tylenol. So we're going to send we're going to continue the probation. He is going to complete the 8 hours of community service. And he is going to submit to urinalysis. Now, what we're going to do is he's going to come in by the close of business Friday. He's going to come in by the close of business Friday, and he's going to submit to urinalysis. I know that it's going to be positive. Already know that that's going to be positive. he has to submit to your analysis at 36 District Court by Friday. That's going to cost him $10. And then on his review date, he's going to submit to your analysis again. If that drug test is not substantially lower or has disappeared, then we're going to have an issue. We're going to have an issue. So I'm going to set his review for an in-person review so that he can test on the day of his review. How many do I have on Friday, September the 22nd?
Just 4?
Cases or reviews?
Oh, 4 cases.
Okay, that sounds like a good day to take a vacation. Nevertheless, I won't. All right. I'm going to set his review for Friday, September 22nd at 9:02. That means in person. September 22nd at 9:02. And then when he comes in, Mr. Flanagan, we're going to make a note on the file that he is to be sent to the lab for urinalysis.
Okay. Make that note.
Anything further?
Nothing further, Your Honor.
May I ask a question?
You might want to ask your lawyer in the breakout room before we go on the record with it.
I can go back to breakout with Mr. Sledge now.
Okay. I'm going to send them to number 3. Okay, Mr. Flanagan, do we have an update on Langowski?
Oh, yes, Your Honor. I sent you a chat.
Oh, okay, thank you. It's not true. It's not true. I'm looking at the order. I'm looking at the order. Who said that? I'm looking.
Ms. Bumpus.
Who?
Ms. Bumpus.
Hold on. Where did I do with Ms. Langowski? Oh. So you telling me that Brittany Langowski did not get ordered to pay $810, and then her order does not say, shall not violate any laws, must report monthly, must notify probation officer of change of address and work status, shall not use or possess any illegal substances, shall not use or possess any marijuana without a valid medical marijuana card, shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor, shall not drive without a valid driver's license, 4 weeks of anger management, must continue with mental health treatment, maintain no contact with complaining witness Crystal Harris. You're saying that's not her order?
Everything is listed except for the continue with mental health treatment.
I have this order right here in front of me. So what are you saying? It's 2 orders.
I'm looking at the order of delayed sentence that's in the file.
Okay, Jesus. All right. I want proof of her mental health treatment before I discharge her from probation. I just can't imagine why that wasn't on there.
Your Honor, respectfully, Ms. Langowski has followed the court orders and has continued.
Mr. Gregory, I want proof of her mental health treatment before I discharge her from probation. She has indicated that she has been in treatment even before she was sentenced. Getting proof of that treatment is immediate and easy.
I understand, Your Honor.
I'm not discharging her from probation until I get proof that she is in the mental health treatment. Anything further? Because I'm gonna give her a week to get us that proof.
I just want the record to reflect that
The
she
record
did
reflects it.
follow
The record reflects
the court orders.
Gregory, I'm not
I
gonna
understand,
argue.
Your Honor, but I would listen, Your
Mr.
Honor. I
Gregory,
would like to make this on the
Mr.
record.
Gregory, Mr. Gregory. I want proof of her mental health treatment. So if that is going to reflect, I'm amending the order to be what I said on the record, because we can get the transcript. So if I'm
Your Honor,
amending
that's
the order to
that's
reflect
true.
what I
That we
said
can get
on
the
the
transcript,
record,
but you did an order was filed on
Mr.
the file.
Gregory, do not ever interrupt me. If it's an issue of me amending the order to reflect what I said on the record, then that's what I'm doing. I'm amending the order to reflect what I said on the record, which is continue in mental health treatment. And since Ms. Langowski has said today that she has continued in the mental health treatment, then it's no issue. I don't even know why we're discussing it. So she's going to get the proof that she has continued in the mental health treatment, and then I'm going to discharge her from probation.
Understood, Your Honor, but everything that is an amendment on the record should be discussed.
This is going south. It's really going south at this moment. It's really going south. I'm going to say this for the last time. That's my order. That's my order. I'm going to say that for the last time. That's my order. Ms. Langowski, how long is it going to take you to get proof of the mental health treatment?
I can drive up there right now and get the paper. I go down the street to therapy. So do I just upload it somewhere or send it somewhere?
Yes, you're going to send it to, you can send it to Ms. Bumpus, or you can send it to Mr. Flanagan.
And then I
Your
have to
Honor,
come
if you
back.
can get that paperwork in today, would that be able to?
Absolutely.
Would it be able to be this?
Absolutely. Do you need Mr. Flanagan's email address? They may not be able to give it to you today. But if they give it to you today, you can send it today. And if not,
they gave me one. My lawyer was Scott Weinberg, but he's not my lawyer anymore. So I'm assuming he didn't upload it, but they gave me a paper back when I was supposed to do all this, and I thought it was all uploaded. But they'll literally give me a sheet of paper today saying that I'm in treatment.
okay, well then let me give you the email address to send it to.
Okay. Okay, I'm ready.
Christopher, CH, RISTOPHER dot Flanagan, FALNAGAN
NAGAN
at 36TH District DISTRICT Court, one word, districtcourt.org. Christopher.Flanagan at 36TH districtcourt.org. That's the numbers, 36.
Okay.
If you email him that today, I will dismiss the matter with prejudice. I will remove the conviction from your record, and I will close the case with improvement.
Okay, thank you.
If you cannot get it to him today, call the courtroom and let them know when they say they can get it to you, okay? If for some reason they can't. So do you need the courtroom phone number?
Yeah, I was supposed to call Ms. Bumpus after court today too. So I can send it to both just to make sure it gets there.
Okay, that sounds great.
Okay, and what's the court number?
965 2295.
Okay, thank you.
All right, you're welcome. Have a great day. Stay safe.
You too.
Thank you. Mr. Flanagan, send me that order because I'm trying to figure out why you have a different order than I do.
Okay.
Thank you. Okay, let's see. Ms. Ritter, are these people? Wait a minute, let's see. Are these your witnesses or something?
No, Judge, Mr. Crenshaw is under 9 AM. And I was looking on my list, I don't see Ms. Holmes.
Oh, yeah, okay, I see Mr. Crenshaw. Let's go with Holmes then, let's see. Mr. Gregory, did you all already speak to Crenshaw?
Think so.
You said what? I'm sorry.
I'm unaware, Your Honor.
Okay. Ms. Stevenson, did you speak to Crenshaw?
No.
All right. Mr. Crenshaw, what happened? Unmute, Mr. Crenshaw.
Do you hear me?
Mr.
Yeah.
Crenshaw, what happened?
Yeah. No, when I was in the breakout room, when then nobody come, and the Wi-Fi came off, and I joined right back, and then you just put me in.
I'm going to send Mr. Crenshaw back to the breakout room. He's going to wait there until somebody comes in to speak with him. Ms. Holmes, unmute and state your name.
Good morning. Can you hear me?
Ma'am, state your name.
Tasha Holmes. I'm sorry, I was logging in for Damon Crenshaw. Our internet was acting up, so I had just logged in on my computer for him.
Okay, so is Mr. Crenshaw going to be on your computer or is he going to be on his device?
His device is working now. He's actually in the meeting with the lawyer right now, so I'm just going to log off.
Thank you.
Yeah, thank you.
Did Mr. Reese's come in person?
No, Your Honor.
Thank you. All right, looks like we're ready on Crenshaw.
Sorry about that, Judge.
No problem. This is case number 234412601, the people of the state of Michigan versus Damon Willie Crenshaw. The defendant is charged with 1 count of malicious destruction of property. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Damon Crenshaw. Mr. Crenshaw, please unmute and tell the judge your full name.
Damon Willie Crenshaw.
Today is the date set for final pretrial conference. How are we proceeding?
Your Honor, at this time, Mr. Crenshaw will continue his plea of not guilty. We're going to ask that this matter be set for jury trial, Your Honor.
The court is going to continue a not guilty plea on behalf of Mr. Crenshaw. I will set the matter on the jury trial track, giving Mr. Crenshaw a final pretrial conference. Of March the 1st, 2024 at 9:19. Bond will continue. Anything further?
No, thank you, Judge. No, thank you, Judge.
I have discovery, but for the final pretrial conference, it looks like other than the alleged victim, it looks like there's a necessary witness.
Ms. Stevenson, you're not gonna keep on making the people prove that they can prove their case before the trial. So if the complaining witness is available, that's up to Ms. Ritter, if she can prove the case beyond a reasonable doubt.
All right.
So if you say you see a necessary witness and she don't think the witness is necessary, that's her business.
Okay, I get it, Judge. I'm just looking at the investigator's report, and the complainant said she didn't see anybody do anything.
Okay,
So
well,
for that
other
particular
proof.
instance,
I don't know. That's on Ms. Ritter. If Ms. Ritter ain't gonna read it and know, that's on Ms. Ritter.
okay. All right. I don't have anything further, Your Honor.
All right, then we're all set until March 1st at 9:19. Mr. Crenshaw, if you need a reminder of that court date, you may want to go onto the court's website and sign up for text notifications of the court date.
Yes,
they will send you a text message about 2 weeks before the court date, okay?
Okay.
Have a great day. Stay safe.
You too.
Thank you.
Thank you, Your Honor.